Good afternoon, viewers. As you all are aware that Ministry has recently amended the Companies Incorporation rules through Companies Incorporation Amendment Rules via its notification dated 21st of February, which provides for a form company active, which is impacting every company, and these are effective from 25th of February. So, according to this, every company incorporated on or before 31st of December 2017 is required to file this form. So, based on this form, we have received lots of queries which needs clarification on the form, and as a part of knowledge building initiative and as per our webinar series, we have requested the Ministry of Corporate Affairs to clarify the issues and whatever are the practical aspects with regard to this form. So, Ministry has very kindly agreed to come and share the views on this form. So, I am thankful to the Ministry of Corporate Affairs, and I will briefly introduce. He is Mr. KMS Narayanan, Assistant Director from the Ministry of Corporate Affairs, Mr. S. Bhaskar, Principal Consultant, Infosys, Mr. Shashiraj Dara, Deputy Director from Ministry of Corporate Affairs, Ms. Jasna, E-Governance Cell, MCA. Thank you all. I request you to now proceed and please give the brief introduction about the form and the clarity on the form.
Thank you, ma'am. Good afternoon, friends. Good afternoon, professional colleagues. A very warm welcome. Ministry of Corporate Affairs has come up with a new form called INC-22A with effect from 25th February. As you know, this is a very simple form. Most of the fields in this form are pre-filled. You just enter the SIN number and everything is pre-filled except for three things. One is the lat long of the company, the Gmail of the company, and you have to attach a photograph, one interior and the other exterior. With this, I will like to introduce Ms. Jasna to take you through the deck, and then we will be answering all your queries.
Good evening, friends. Let me just take you through a deck which is prepared to kind of a guidelines for you people to help understand the form and how the processing of the form takes place, how the form what is expected out of the form and how the same has to be filled. So, I will take you through this PPT. So, the objective of the eForm active. The objective from MCA point of view for the eForm active is to identify and monitor through a single form the companies which are violating the various applicable provisions of Companies Act 2013, and also to enable the common public to be aware of the know your company status of the companies and their directors. So, basically it is a way to verify all the details that are present with MCA related to a company. So, the points that we are going to cover through this PPT are the key features that are introduced in the form, the data fields, the precautions that have to be taken for filing the form, the implications of not filing the form within the due date, and what about what happens if the form is filed after the due date. So, the new features that are introduced in this form are related to the verification of the registered office address along with geotagging. So, this is the first form within MCA whereby the geotagging, the latitude and longitude of the registered office address is being captured in the form. Other than that, similar to what we had for DIR 3 KYC, the OTP verification of the phone number and the email ID, similar to that we have an OTP verification for the email ID of the company in the active form. Also, the verification of other details like the director details, statutory auditor details, cost auditor details, KMPs as well as KMPs including company secretaries. So, all the details are verified through this form. Please remember that this is only a verification of all these details. None of the details are supposed to be entered and updated through this form. Then we move on to the details of the annual filing forms. So, the details of annual filing forms that are available with MCA will be pre-filled in the form. So, basically again this information is again a verification of what are the details of the annual filing forms that you have filed with MCA, and based on that you will be enabled or disabled to file this form. Only one attachment is a mandatory attachment to this form, and that is the photograph. Now, the photograph should be as per the details of the attachment. It says the photograph of the internal as well as the external building of the registered office, as well as showing one of the directors or KMPs who has affixed his or her DSC on the form. So, we will move on to the form now. We will go field by field. So, if you look at the first field, it says the SIN of the company. Since, as we already discussed, that this form is more of a verification form. So, except for 3 details, everything else is supposed to be pre-filled. So, if your company is up to date with all the filings, all the data is up to date, then there should not be any problem in filing this form. You just need to enter the SIN of the company, click on pre-fill, the name, address, email ID, and whether the company is listed or not. These details gets pre-filled based on whatever is the information available at MCA database. Please remember that the latitude and longitude fields have to be entered based on the geo details of your registered office address. Email ID of the company, although it is pre-filled based on whatever data is available in MCA, but this is an editable field. So, you may edit this field and update your email address of the company, so that the OTP which is sent to the valid email address of the company, and this has to be verified by OTP. Again, you see the send OTP button and verify OTP button over here. If you look at the screenshot, these buttons are disabled as of now. These buttons get enabled only once you are once the successful pre-scrutiny of the form is done. After successful pre-scrutiny, the send OTP button gets enabled, and on click of the send OTP button, the OTP is sent, which is valid for a period of 30 minutes. So, that OTP has to be entered and then verified. Only after that you can successfully upload the form and submit the form. Whether the company is listed or not, again this depends upon what data is already available at the MCA database. Next, we move on to the second field, which is about the number of directors. On the click of pre-fill button, the number of directors which is updated in my MCA database gets entered, and based on that the table containing the list of directors as on the date of filing will get populated. Please note that the field 2B, the maximum number of directors are beyond prescribed limit. Now, this field gets enabled and is mandatory wherever the number of directors exceed 15, except for Section 8 companies and except for Section 8 companies and government companies. Also, one thing that needs to be taken care of, if you look at the table in field number 2C, it contains the DIN, name of director, and the status of DIN. So, the status of DIN, this column should not contain any value other than approved. So, basically if the status of a DIN is disqualified or is deactivated due to non-filing of DIR 3 KYC, it will get pre-filled. However, at upload the form will not be, you will not be able to successfully upload the form, because the expectation is that all the directors of the company must have an approved DIN status. Let us move on to the next field, which is the details of statutory auditors. So, as we discussed earlier, all these details get pre-filled based on whatever data is present in MCA as per filings done with MCA, previous filings. So, if you find that the details are not updated, probably the relevant forms have not been filed. So, the advice is to file all those relevant fields, and once those forms are filed, then these details will automatically get pre-filled in the form, and only then you can proceed to file the form. So, based on the number of auditors appointed, so based on this number that gets pre-filled, the various blocks will get generated. For example, in case of joint auditors, probably the number that gets pre-filled would be 2. Then you will have 2 separate blocks for the details of auditors to be entered. One thing to be noted is the period of account for which appointed, from and to date. Since we are looking at the updated information, whether the information with MCA is the updated information or not, So, the point to be noted here is that the period of account for which appointed, the to date, must be on or after 31st March 2019. So, basically we want to ensure that all the latest filings have been done or not. The field number 4, which talks about appointment of cost auditors. So, whether the company is required to appoint cost auditor is a field which you have to enter. That means yes or no has to be selected based on the type of company. So, if the cost audit rules are applicable to you, you have to select yes. And in case yes is selected, you have to click on the pre-fill button for all the cost auditor appointment details to be pre-filled, similar to the statutory auditor details. In case the company is not required to appoint the cost auditor, you can just click on no and proceed. Again, the same check over here, the financial year to be covered, the to field must contain the period as at least on or after 31st March 2019. The details of managing director or CEO or manager or whole time director of the company. Now, here the number of roles get pre-filled first of all, and depending upon the number of roles, the blocks below gets populated. Okay. So, first of all the director details get populated based on the designation. The blocks will get populated. For example, first of all, if there is a managing director, the details of managing director get populated, then the details of CEO will get populated, and then the details of manager will get populated. And if none of these are available, then the details of the whole time director gets populated first, and so on. And then we have, after these director details only, we have the details of company secretary, and then we have the details of CFO. The last field in the form relates to the SRN of the annual filing forms that are filed with MCA. Basically, the forms AOC 4, AOC 4 XBRL or MGT 7, and specifically the pre-fill happens for the financial year 2017-18. So, in case none of the SRNs are getting pre-filled, please go and check the status of the annual filing forms. Now, the attachment, the only attachment available or required to be given in the form relates to the photograph of the registered office. We have some standard photograph, we have tried to put some standard photograph, the manner in which a photograph of the office is expected to be shared with MCA. We will show you the photograph. The next section is related to the declaration and verification. Now, one point to be noted over here, which we realized post some forms getting filed, is this form is supposed to be signed by one director in case of an OPC, but if it is other than OPC, it has to be one director and either the second director or any of the KMPs. However, please ensure that the person who is affixing the DSC, the individuals are separate, different individuals. It should not be the same person affixing his DSC at all the places, including the professional certification. We have come across various cases where we have seen that that one individual is affixing his DSC at all the places, which is not correct. Certification. So, this certification part has to be verified or certified. This has to be certified. The form has to be certified by a practicing professional, and the details of the practicing professional who is certifying are again captured in the form. So, as you see, the normal way the form is processed: check form, then pre-scrutiny. On successful pre-scrutiny, the OTP verification happens, and only after successful OTP verification the form will be allowed to be uploaded. So, this is the standard photograph. This is how the standard photograph is supposed to be. This is how MCA expects the photograph to be shared in the form. So, if you see one of the directors is there in the form, there is an external building containing the registered office address. Along with this person has tried to capture the latitude and longitude also. It has been shared in the same photograph. Similarly, the second photograph, if you see, it has the internal office. It shows the photograph of the internal office. Okay. So, certain precautions that must be taken care while filing this form. First of all, in the director section, the minimum directors limit should not be breached. So, depending upon the type of company, if it is an OPC 1 director, private company 2 and public company 7, those minimum director limits should not be breached in case of filing of INC-22A, or else the form filing shall not be allowed. Similarly, in case maximum number of directors exceed the prescribed limit, then the SRN of MGT 14 with the purpose appointment of more than 15 directors must be given. That SRN of form MGT 7 should be entered, it should be a valid SRN, and that SRN should have been filed with this purpose. Then, as discussed earlier, company with all directors with DIN status as approved shall only be allowed to file this form. So, if any one of the directors is also having a status other than approved, this form filing shall not be allowed. Then, in case of listed company and other public company having a paid up share capital of 10 crore rupees or more, the company shall have. So, again this is a mandatory requirement. This has to be taken care. So, probably why the form filing may not be allowed to a company could be this could be one of the reasons, that either MD or company secretary or CFO is missing, but the company is having a paid up share capital of 10 crores or more. So, if any of the company fall in this criteria, then they are supposed to have MD, CEO or manager, and if none of these three are there, then a whole time director, and then and a company secretary and a CFO. So, there are 3 positions for the KMPs. Further, in case of company having paid up share capital of 5 crore rupees or more, they must have a whole time company secretary. However, this government companies are excluded from this requirement, and same for the prior requirement also. Then the company must ensure that it has filed all its due financial statements and annual returns, and the form must be signed by 1 director in case of OPC and signed by 1 director and 1 KMP, or 2 directors in case of other than OPC. Now, let us move on to the implications. What happens if you file the form? Now, company's active compliance status shall be updated as active compliant or active non-compliant based on filing or non-filing. So, if you have filed your company active form, then the company compliance active compliance status will be marked as compliant, and if you default in filing this form before the due date, that is 25th April 2019, then the status will be marked as active non-compliant. What happens if the company is marked as non-compliant? All the directors of such active non-compliant companies shall be marked as directors of active non-compliant company. So, all the directors will also have an impact if the company does not file the form. And which all forms shall not be allowed if the company is marked as active non-compliant. So, these forms are prescribed in the rules, which include SH 7 for change in authorized capital, PAS 3 change in paid up capital, DIR 12 changes in director except cessation, INC 22 that is change in registered office, and INC 28 for the purposes amalgamation and demerger. So, once the company is marked as active non-compliant and later on after the due date the company files this active form, then how can it be filed? The active form post the due date can be filed only along with the fees of rupees 10,000. Company's active compliance status, once this form is filed and being an STP form, once this form is marked as approved, the company's active compliance status shall be updated as active compliant, and the directors of all such companies. Now, as discussed earlier, the directors, since all the directors of active non-compliant companies are marked as directors of active non-compliant companies, that flag will be removed for a director only if he is a director in all the active compliant companies only. So, if you are a director in 5 companies and even if one of the companies is KYC active non-compliant, then in that case your director status, your director flag of director of active non-compliant company will not get removed. That is it from my side. Thank you.
Anyway, when I shall take up a few more things which I want to indicate here before going up with the other questions. That is lat long. We have been receiving many questions relating to lat long. We have been, as company secretaries or other professionals as a chartered accountant also, we have been filing our charge related forms, and we have been certifying our forms of charge related forms, where we have been using a lat and long facility. This lat long facility is only unique, for the first time introduced only for the registered office. So, I hope all my professional colleagues will understand this, and I do not think so there is any problem in getting this lat long for all my professional colleagues. Then there are other questions like whether appointment of an auditor, cost auditor, manager. We will go along with the questions and be answering one by one of them.
So, next question Daraji being can we attach two photographs, first of external building photo and second inside office photo, whether either director or company secretary sitting. The said director and CS are signing the said form.
Yeah, this is the requirement of the rule, which clearly says that one photograph with the registered office clearly visible, and the director, one director or KMP, it can be a director and any KMP who is signing the form, should be there in the photograph outside the registered office and one in the registered office.
Yeah, an ideal photograph has also been shown in the deck presented by Jasna. Please follow the ideal photograph that has been shown.
I would like to add here that just a pictorial representation.
Yes.
Please do not take it as a rule.
Yeah. And the third question being, if GNL2 has been filed by the company, then form is not accepting any option, what to do? Before Daraji reacts, let me tell you, we have examined many GNL2 forms wherein others option has been chosen while filing the appointment of auditors attaching ADT 1, and we have realized that in many of the GNL2 forms, though the ADT 1 form was available. Let me tell you for the clarity of the members who are watching this webinar, effective from 1st April 2014 till 20th October 2014, ADT 1 was not available, and then MCA has issued an advisory advising stakeholders to file ADT 1 as an attachment to GNL 2 opting others option. Effective from 21st October 2014, ADT 1 eForm was available, but still based on the filings done for GNL 2 and based on the tickets raised by various stakeholders, we have arrived at, even after making available the eForm for filing purposes, people have ignored filing ADT 1 eForm to dodge filing of form with applicable fee and additional fee. They filed using GNL 2 others as the option. Daraji, please elaborate further, and what is the action which MCA is likely to take in this GNL 2 ADT 1 cases?
Firstly, if you have filed GNL 2 after the due date, I do not think so there is any claim for any person. Point number 1. Point number 2, for all those cases for which GNL 2 has been filed, we are examining it and will come out with some clarification on this in few days.
Yeah. Shankarji, would you like to add anything here?
Yeah, good evening stakeholders, and thanks for ICS for arranging this webinar. And first of all, I tell you the professionals need to go through the rules and the forms thoroughly. That is the first one of the main aspect you need to go through. As far as GNL2 issue is concerned, and for whatever we have issued circular, in between if it is false, we will examine separately and we will try to come up with a solution. But those who have already, those who have filed beyond the deployment date, that is 20th October 2014, they need to file ADT 1. There is no option is available. They have to compulsorily, mandatorily to file the ADT 1. Over to Mr. Bhaskarji.
Daraji, next question being, how do we certify the genuineness of photographs?
This genuineness of photograph need not be certified. There is a mandatory requirement that INC-22 has been filed. I will again reiterate here, the form INC-22 is basically a pre-fill form. It does not have any all data which is available with the MCA based on the periodic filing and annual filings of the company is updated in the form INC-22A. Therefore, friends, if the registered office address is changed or is correct as per INC-22, then genuineness of the photograph is already certified there.
Yeah. Next question, Daraji, is on, can we put email ID of one of the directors or of a company secretary instead of email ID of the company?
You have to be, it is your risk and cost at which you may be putting your email ID, because email ID has an implication in Companies Act, especially after the new Act 2013.
Yeah. Next question, the attachment of the form is photograph of registered office showing external building and inside office, also showing therein at least one director and oblique KMP. What does it mean therein? Meaning photo of director oblique KMP mentioned in both, that is external building and inside office?
Friends, we have already shown you a pictorial representation of how that should be. Again, I will, for the benefit of all our members, again I will repeat it. The first photograph should be outside the registered office, clearly showing the registered office address and one of the director or KMP, whoever is signing the form, plus the same director or KMP inside the registered office.
Next question, what can be done in case registered office address of the company is residential address of a director? Then in such case, what kind of photo is expected?
I think this question has already been answered. Whether the registered office, what registered office is declared in INC-22 is the registered office. It does not matter whether it is registered office of the director or so, if it is in compliance with the requirements of the Act and rules.
Yeah. Total, how many photos we require to attach in the form?
Total 2 photographs, one of the exterior and another interior.
How to mention latitude and longitude in the form INC-22A?
Professional colleagues have already been doing this in charge related forms. I do not think so there is any clarification required from MCA side or any side. It is easily available.
Yeah. And regarding ADT1 and GNL2, many questions have been asked. We have already very clearly responded to ADT1, GNL2 issues. So, let us go to the next question. What is the procedure for changing the email ID of the company?
Friends, again here I would like to add that INC-22 form is just a pre-fill form. It is pre-filling all the data available with MCA based on the periodic filing and annual filings of the made by the company with MCA. Therefore, if any change is required, like if there is a change in the registered office of the company, then INC-22. Then if there is a change in directors of the company, please file DIR 12 and come back. If there is any change in email ID of the company, please file MGT 7 if you have not filed. If there is any change or you have not filed ADT 1 for appointment of the auditor, please file, then come back and file INC-22. It is very simple form. Again, I will tell you our requirement of MCA is we try to make the form very simple so that there is no problem for neither the company or the professionals to fill this form. Everything is a pre-filled if you have complied with all the provisions of that.
Jasna wants to add something on the changing the email ID of the company in the form. Over to you, Jasna.
Yes, actually, the email ID of the company is an editable field in the form active. So, if the email ID has to be updated, it can be updated through this form, because since we are doing an OTP verification, this is the only data which gets updated in the master data of the company.
Please be aware that the professionals need to give the email ID of the company, okay, not of the professional. The expectation here is the email ID of the company has to be given, not the professionals. Okay. Accordingly, take note and give the email ID of the company. Okay. So, Daraji, next question. Similarly, whole time directors are also not appointed. What is the solution?
You have to appoint the whole time directors in DIR 12, then come back and file INC-22.
Next question, on MCA website 3 names of directors are shown and the form is pre-filled with name of all these 3 directors. The director has confirmed that there is dispute with one director who has already resigned and filed DIR 11 for his resignation, but the company has not filed DIR 12 as there is litigation going on in NCLT with reference to his resignation. In these circumstances, as a professional, I suggest to attach a clarification letter informing these details and attach it as an optional attachment in form INC-22A. Is it correct, or do you have any other suggestion?
Here we do not have any suggestion, since the matter is sub judice with NCLT. Please get it corrected and then come and file form.
Next question is INC-22A applicable for all companies?
See, once again you kindly go through the rules. We have provided the exemption in case of the companies which have been struck off, or under process of striking off, or under liquidation, or amalgamated, or dissolved, as record and listeners shall not require to file. Therefore, even government companies are also required to file this form. There is no exemption for government companies, and there is no exemption for dormant companies. Dormant company may be having some technical difficulties, and we will shortly coming up with the solutions. So, except this, every companies are required to file, including government companies.
Okay. Shankarji, next question, how many companies can have a same registered office address?
See, there is no the particular law in which how many registered office can be there, but you need to practically see how many registered office can be operated in a particular premises. Depends upon the space and everything. So you need to see the premises, how the registered office can be run in a particular premises.
Please confirm my views that the professional, before certifying this form, must visit the registered office inside and outside both, and take picture for the record too with the date stamp.
It is better if ICSI or relevant professional institute issues some clarifications on this.
Yeah. Next question, Daraji, is on group companies. In case of group companies, can a single photograph be used with a common board outside building with all details?
The photograph can be used or not used depends on who the directors are, what the registered office is, and who is signing the form. So the rule says one photograph outside the building, one photograph inside the building with the director or the KMP who is signing the form. If that requirement is fulfilled, anything can be done.
Yeah, this is a repeat question, but for more clarity, let me reiterate. Pre-filled details of statutory auditors in para 3 on page 1 of form 22A is not pre-filled in cases where the company had filed ADT 1 with form GNL 2 prior to 20th October 2014 being the date on which ADT 1 was notified by MCA. The technical issue needs to be corrected by MCA. There is no technical issue in this. MCA is examining the forms filed with these dates, that is from 1st April 2014 to 20th October 2014, and we will come up with suitable advisory shortly. Okay. Next question, many group companies are having same registered office address with proper space allocation, different staff with the same email ID. What is the way out for such companies with regards to email ID, longitude and latitude?
The question asked is relevant. Email ID has an implication in Companies Act 2013 read with the rules. Therefore, email ID, it's better to have a company email ID and prefill. As regarding latitude and longitude, it depends on the photograph which you take, and latitude and longitude we have been using in other forms like CAG 1 and 4. You can use same latitude and longitude for the registered office.
Next question, our company carry their business activity through corporate office and not at registered office, then for INC-22A, do photos of corporate office will suffice?
No. The basic question is, as per section 12, you need to maintain the registered office. So the photograph, the registered office only is mandated, not the corporate office address.
The company had not completed annual filing on due date. Hence, directors are disqualified under section 164. Now, filing is made up to date by appointing new directors. But disqualified directors have not resigned, as they are not required to resign from defaulting company. But form does not accept the disqualified directors. How to resolve this issue?
As regarding disqualification, please check the section and rules. Section says 6 months are allowed, not beyond 6 months. Therefore, it is mandatory for the director to resign.
as a professional, by certifying the active form, I am not supposed to check whether the registered office is owned by the company or leased, and whether NOC is obtained for such use of premises by the company at its registered office. For many companies, the earlier form 18 was filed under Companies Act 1956, and now since the form is like KYC of the company registered office, my advice is to check the ownership, rental or leased premises and NOC of owner to avoid any future litigation queries from the regulators and owners of premises.
This I think query is very generic. However, since as a professional you are certifying, please take advisory from the relevant institute.
It is more of a submission rather than a query from the stakeholder, Daraji. Is it possible to rectify ADT 1 now, as the incorrect period of appointment mentioned in it and resulting into difficulties in filing INC-22A active?
I do not think so. You can do any rectification in ADT 1, because ADT 1 is already once filed is always filed.
It is the ultimate decision would be taken by the ROC whether this form can be marked as defective. Okay, if the form is marked as defective, then ADT 1 can be filed with applicable fee and additional fee, but it is a call which ROC, the jurisdictional ROC will take.
But I do not think so ROC can take the call, because it is a non-STP form till recently. So, it depends on situation. It is better to consult the concerned ROC.
Jurisdictional ROC.
Jurisdictional ROC.
See, I will tell you, I really very sorry to say the incorrect form. You are certifying, the professional is certifying. Before filing the form, you have to see what are the contents to be filed. You need to check. If it is wrongly filed, you again file with the additional fee, with the relevant details. That is the only solution. We cannot mark ADT 1 as a defective. It's a straight through processing method, and we cannot mark it as a defective. You file with ADT 1 fresh ADT 1 along with the fees.
C&AG has appointed our statutory auditor, and hence we are not filing ADT 1. Hence, while filing form active, auditor details are not getting pre-filled. So, I am unable to file the form, and error message is showing how to file my form active.
ADT 1 is to be filed.
By every
it is
company.
not to be filed by it is not to be previously like old Companies Act 1956 Act. It is not to be filed by the auditor. It is to be filed by the company. Whoever appoints the auditor, whether it is appointed at the AGM or by the C&AG, form has to be filed by the company. Company has to file the form and then file INC-22A.
See, there is no exemption is given to the government companies not to file the ADT 1. Every company need to file the ADT 1. So, it is a matter of appointment of auditors, whether it is CAG through or whatever appointed through by the management, with the shareholders approval. So, you need to file ADT 1 irrespective of the government company or not.
We have analyzed some of the issues flagged by these government companies while filing this active form with specific reference to auditor's appointment, and it is reiterated that some of the stakeholders, they have slightly confusing themselves reading 139.1 and 139.5. The advice to them would be, please file ADT 1. Now, the ADT 1 enables filing of auditor's appointment by the government companies as well. Once you file ADT 1 and it gets approved, you can file a active form. Okay.
I'll read out. It is whether it is mandatory to attach a photo of the director which is clicked at the time of putting DAC, or we can use photo clicked before putting DAC, says 2 days before clicking the photo. I think this has been sufficiently answered. The photograph does not have requirement that director should be signing the form. The requirement is one photograph outside the registered office, one photograph inside the registered office with director or KMP, whoever is signing the form.
Next question, Daraji, is on whether a whole time company secretary not being a KMP, can the photograph be affixed?
I do not think so. Rule permits it.
My query is regarding the photograph of the premises and on director inside the registered office. What should be kept in mind while taking the picture, like whether the nameplate of the company should also be featured in the photograph taken, etc. I think that
has been sufficiently answered, and a sample has also been shown.
Yeah. So I am avoiding the questions related to photograph because we have very detailed answers have been given, and an ideal photograph has also been shown in the deck.
And you please also comply section 12 of the Companies Act. It is clearly written what has to be displayed before the registered office, name and address of the company. Then you please comply with the provisions of the act, that is section 12 of the act.
MD of the company is also the company secretary. His digital signature has been registered with the MCA as director with his DIN and as company secretary with his PAN. Now, can he affix his DSC as a director and also as a KMP, that is as a company secretary, giving his AACS membership number? Whether he can do it, that is the question.
I think this question is being asked by a company secretary himself. I don't think so he can do it. It is better he reads the provisions of the act and answers it himself.
Just now in our deck already clarified, multiple signatures of the same individual is not permitted in the active 22A form. Please be compliant to the provisions of the act and the rules and the active form. Okay. Next, how to check latitude and longitude further with relates to registered office photographs where the company is at second floor of apartment, whether do we need to capture the full apartment, second floor outside office and inside office, or only second floor outside office and inside office?
This has been sufficiently answered. You please look at the deck. We have given a sample photograph also. Please follow it.
What is the responsibility that a professional is taking while certifying the form 22A?
I think institute has to bring out some guidelines in this regard.
In the case of group companies, a unique email ID may be used for all companies. Is it acceptable in eForm INC-22A?
As already specified by Jashna also at the time of the deck, the email ID here is the only field which is editable in form INC-22A. This is for the purposes of obtaining an OTP on the email ID excuse me, email ID which is mentioned in form INC-22. Therefore, the act permits, the email ID has a validity under the act and rules. So, please comply, read the rules and act, and then try to answer this question.
Yeah. If a company obtained the status of dormant, is it required to file INC-22A active?
It has already been addressed earlier also. The dormant company is also required to file INC-22A, that is form active. So, if there is any technical problem, we will resolve the issue.
If the director of the company has 2 DINs and 1 DIN is deactivated due to non-filing of KYC, then how company will file INC-22A?
It has already been clarified here. Point number 1, if a director has 2 DINs, it is mandatory for as per the Act 2013 for him to surrender a DIN. He has to use form DIR 5 to surrender the DIN. Point number 2, it is very clearly mentioned for the purposes of directors. 1, all the details of the directors in form INC-22 are pre-filled. Please do not try to enter manually the number of directors in that field. It is just a pre-fill. You click on the pre-fill, it will display the number of directors at present in your company, associated with the company, with the status like active, disqualified, disqualified for non-filing DIR3 KYC, deactivated for non-filing of DIR3 KYC, or disqualified under section 164. And below the table there is a clear note which mentions that the expectations of the ministry is that if a director is disqualified or if a director is deactivated for non-filing of DIR3 KYC, then please file DIR 12 and come back and pre-fill the director column again.
Yeah. Next question, how to display the name and other details in case of a group of 30 companies having same registered office and common directors?
I would like to clarify here that INC-22A is filed for one single company. So, there is nothing called common directors. Whoever directors are associated with this particular company, with this particular SIN, are displayed in form INC-22. Point number 2, relating to registered office. The registered office requirements are clearly mentioned in section 12 of Companies Act, which clearly says how the registered office and what is the how the name is to be displayed, how the SIN is to be displayed. Please comply with it.
What if a company eligible for appointment of a company secretary, but company did not comply with the said provision?
Shankarji would like to answer this.
See, the company secretary needs to be appointed by the company. If it is exceeding the limits prescribed under section 203 read with the rules thereunder. If the company is not appointing the company secretary, and they will face the prosecution. So please appoint the company secretary and comply the law and file the active form.
Liquidation order has been passed by NCLT and the same has been filed through form INC-28, but the master data still shows the status as active. What shall be done? This company has not filed its annual return since 2016.
This is a case specific thing. Point number 1 here, since somebody has raised this query, in INC-22 there is a drop down, and that drop down has various options like amalgamation, merger, liquidation. Please use the correct option. We have been seeing in the past also people have been using the others option, which they feel it is an easy option. If you use the other options and you file and you expect the system to update the master data based on others option, system will not update. Please select the relevant thing. Once you select whether it is a merger, amalgamation, liquidation, system will automatically update it. Once system automatically updates, like in your case it is a liquidation, if you have filed INC-22A for the purpose of liquidation, it will show under process liquidation, therefore you need not file this returns. However, this is a case specific, please raise a ticket for this, we will respond to it.
Do we require 2 directors' photographs as we required to attach 2 DSCs?
The rule says one person, either a director or a KMP, whoever is signing the form, not 2 directors.
Yeah. Next question, when the form is opened by typing in the SIN of the company among others, it shows the ADT 1 of past years only, which means that the company has not filed ADT 1 for 2017-18. But since it gives the details of ADT 1 for past years, does it mean that there is no need to file ADT 1 for the year 2017-18?
No, there is a requirement to file ADT 1 for the year 2017-18. If Jashna would like to add something.
Yes, so as we discussed while sharing the presentation, we said that the details of the statutory auditor, the 2 period of the appointment must be on or after 31st March 2019. So basically we are checking the latest filings related to the appointment of statutory auditors.
Yeah. Next question, if both director is foreigners and registered office in India, then how to take photograph in registered office?
Please read the Companies Act and requirement. It says one of the directors should always be there in India. Therefore, please comply with the act.
Yeah. Dear sir, is it necessary to have registered office address and SIN number printed on company name board, as some companies already have nice name board but without address mentioned? Is it mandatory to get new board printed? Also, whether photo of building is mandatory? Thanks.
Shankarji.
See, this is almost a repeated question. So every company need to maintain the registered office as per section 12 of the act, and they need to show the registered office name of the company as well as the registered office address, and after that only they can able to file. So if it is not, if it is section 12 is not complete, they cannot go ahead with the INC-22A.
Next question, sir, if we have 19 subsidiaries private companies having paid up capital of 5 crores or more, do we have to appoint 19 company secretaries? If it is so, it is very difficult in a short span of time and unaffordable also. Please suggest.
There is no suggestion, it is the requirement of the Companies Act 2013. Please comply with the requirements of the Companies Act.
Yeah. Next, it is on DSC. While uploading the eForm INC-22A, an error has been generated that the DSC of director has been affixed in the second field of the eForm is not registered, but the same is registered. Please clarify the same.
Yes, sir.
I think you can raise a ticket, and based on the ticket the issue would be resolved after examining what is the exact issue you are encountering while filing INC-22A and affixing the DSC of the director. If a director is resigning between 1st March 2019 and 25th April 2019, what should company do? Would you like to answer, Daraji?
It is between
1st March 2019 and 25th April 2019, if a director is resigning, what should company do?
it is the mandatory requirement to file DIR 12 within 30 days from the date of the resignation or the board resolution. Automatically the system gets updated and the corrected data will be captured in INC-22. In case of group companies, different mail IDs for different companies is required, or one mail ID. This is the requirement of the Act. Please be aware, please read the section and act accordingly.
Yeah, Daraji, this is a new question. Is the form active one-time affair or an annual feature?
As of now, it is a one-time affair. We will examine it at an appropriate time.
My query regarding filing of active eForm under STK2, query number 1. If company has already passed a special resolution and under process of filing STK2 as 30 days time is provided under section 248, do I need to file active eForm first and need to file STK2 as notification of filing of INC-22A comes in between after passing special resolution and filing of eForm STK2?
See, it is very clear, our rule says very clear, the exempted categories already been covered in the rules. If it is special resolution passed and it is on the way, it is not, it is an active company and you need to file the form number INC-22A. Unless whatever exempted categories is not there, and you have to file the INC-22A.
Is it mandatory to do KYC DAR 3 for directors prior to filing this form active?
Yes, it is mandatory to do DIR 3 KYC before filing this form.
Would multiple blockage in filing of forms will not lead to cascading effect of non-compliance just for active form?
The question is really not that clear. However, what is the meaning, I am not able to understand, Bhaskar. Anyway, there is no cascading effect, it is very simple form. Please file.
Whether we require to click external building photo with director or KMP or only external building photo?
This has sufficiently be answered.
Is it necessary to have the name in local language and in English in registered office address?
Shankarji?
See, that is what the registered office should mention the name of the company, registered office address as per section 12. You please comply section 12 and it will be the sufficient compliance.
What alternative steps are available in case there is some outside director whose status is of a disqualified director?
The form, as we already told, respective field of directors is just a prefill. So, do not try to enter the number of directors in that field. Just press the button prefill. Once you press the button prefill, it will display all the directors as on date available who are associated with the company. If one of the director is having a status as disqualified or is having a status of DIR 3 non-compliant, please file DIR 12, come back and file INC-22A.
Our company is having financial year as calendar year. I think they are having calendar year as the financial year. I think the question has not been correctly phrased. So, our company is having calendar year as the financial year. We are not able to submit details of MGT 7 and AOC 4 for 17-18. Can we file details of year in the year 2017 in the form?
This particular field of MGT 7 or AOC 4 is a pre-filled field. If you have filed, it will automatically get pre-filled. However, this is a very specific question. Please raise a ticket for this and we will.
Sir, I want to add, post Companies Act 2013, there is a concept of uniform financial year under section 2 subsection 41, and as per which the companies, even the companies whose holding companies are incorporated outside India, even they have to have uniform financial year, unless or otherwise they have taken exemption by approaching NCLT or regional director. If they have got the order from NCLT or regional director, please file INC-22A the order, then raise a ticket. We will examine and we will get back to you what is the solution for those impacted companies.
This
otherwise, they have to align themselves with the uniform financial year, that is April to March.
April to March. This may be a specific query. You may have to raise a ticket and get it resolved.
Why the purpose does the firm seek to achieve? What is the purpose that does the firm seek to achieve by requiring DSCs of 2 directors and not just 1 director?
This is a technical question. It is the requirement of the law that 2 directors have to sign it.
Only in case of other than OPCs.
Only in case of other than OPC. In case of OPC, only 1 director.
Yeah, sufficiently answered. What if the company's exact latitude and longitude is not able to detect?
We have been filing, all our professionals have been filing Form CAG 1 and 4 sufficiently with lat long facilities since 2 years. I do not have any doubt on this. Yeah. We can easily get lat long for anything.
Yeah. Sir, on photographs we have sufficiently answered. I will not repeat those questions. Next question is SIN number mandatory in the registered office board?
It is mandatory as per section 12.
Even on auditors appointment and C&AG government companies auditors appointment, sufficiently clarification has been given by the panelists. I will not repeat those questions. Whether 2 unrelated companies can have same registered office if they all are supporting having supporting documents, second company will have a sublease agreement.
It is particular, very specific. If they have complied with all the provisions of that, they can have.
If a company is yet to file balance sheet for 2017-18, still this form has to be filed? It is a question, sir.
Field, as I have already told, all the fields in Form INC-22 except 3 fields are pre-fill. If you have filed, the form will allow you to go do pre-scrutiny. Otherwise, please complete the filings and then do pre-scrutiny.
Yeah, sir, this is a specific query. Statutory auditor details are not getting pre-filled. If the statutory auditor's details are not getting pre-filled, in any case, please raise a ticket, and in the ticket also mention the SRN while filing the ADT1. Whatever is the ADT1 SRN, please mention the ADT1 SRN. We will examine whether the ADT1 has actually been filed. Then we will rectify the mistake if at all it is there in the pre-fill of that particular company.
That is what I mean. It is expected that the professional need to check what are the forms have not been filed, what are the requirements are there. First of all, you pre-scrutiny, pre-verify the documents and whether we have complied before raising a ticket. Once the form is filed, only the system will capture. Please ensure that the relevant documents are filed by the company, by the professionals. Ensure that the proper documents filed with the MCA 21 before filing INC-22A.
In case of small companies with capital less than 3 crores, whether the form is compulsorily to be filed?
Yes, it is mandatorily to be filed for all companies as on which are active as on 31st December 2017. Incorporated.
Should the company have a email ID which is separate from the email ID mentioned for the directors? Could it be different from the email ID mentioned on MCA portal?
It is very, again for the repetition I have to say that the email ID of the company is being captured for specific purposes, and email ID of the company has a specific requirement in Companies Act and rules. Therefore, please read the rules and comply the rules.
A whole-time director and CFO was appointed in 2009 and Form 32 was filed for the same. In Form 32, it provides only one field to be marked, so whole-time director field was marked. In Companies Act 2013, there was exemption from filing Form DAR 12 for those who are holding the same designation under previous act. So, no form was filed. Now, in active form, it is showing pre-fill error as CFO is not appointed by the company. In Form 32, there was no provision to select dual designation and DAR 12 was not applicable. So, what would be the answer in this case?
This is a very specific case. Please raise a ticket. We'll examine the case, what has been filed in Form 32, then we can respond to it.
Yeah. Is it mandatory for the professional to visit the registered office of the company before certifying the form active?
I don't think so. As I have already told, the registered office of the company is pre-filled. If there is any change for the company to change in the registered office of the company which the company wants to do, or if it has already filed INC-22, then there is no requirement.
Daraji, his question is whether
the stakeholder, the professional is need to visit the registered office or not. So that
I understood, Shankarji,
let me answer this question. See, you are the professional. Whatever care, whatever the due diligence you need to take, that you have to take a call. It is not the either MCA will not take a call. At the maximum, we will request the ICSI to put some certain guidelines on this.
If a director's DIN is deactivated, then can we proceed with the KYC requirements in April so as to ensure the compliance of KYC with respect to financial year 17-18 and 18-19?
If a director's DIN is deactivated for non-filing of DIR3 KYC, I don't think so the form will. Please do the required compliances as per Companies Act and then file.
That is what one must, professional must have a clear chart before filing a INC-22A. First of all, whether DR KYC is filed, whether the director is disqualified or not, whether the complaints has been made for as per the last rules and forms notified. You should have the MIS system. What should be done, what should not be done. Then you file. Finally, you should file the INC-22A.
If I passed a special resolution after notification, that is 25th February 2019, do I need to file active first or STK2? Active first and STK2. That is the question.
What query 2, if I pass special resolution after. Acha, this was a query which was asked earlier, Bhaskarji. This is with respect to filing of STK2, where he has passed a resolution for filing STK2. This I will answer, Bhaskarji. It says if he has passed a resolution for filing of STK2, he can file MGT 14 with the special resolution. Automatically, the status of the company will become under process strike off.
Yeah, under process strike off companies, they are not expected to file active form.
Longitude and latitude has already
been
sufficiently been answered.
Darajit, it's a new question. If a company is also required to file consolidated financial statements with the registrar of companies, but has not filed the same by default, then whether Form INC-22A can be filed. In this case, the company has filed its standalone financial statements with the registrar of companies with form number AOC 4.
It has to complete the formalities of filing consolidated statement because it is the mandate of the Act. Whether the nameplate, if the company wants to apply for strike off without filing INC-22A
active.
2A active. Yes, it can file.
Yes. Let me read out the question again for more clarity. If any company wants to apply for strike off without filing INC-22A active.
Yeah, it can file.
His director must be needed in photo of registered office or cabin.
The rule says director is required outside the register office as well as inside the register office, and the same person who is signing the eForm INC-22A.
If registered office situated in a complex at which number of other offices are present, how the photo of registered office be taken for specific company?
Please read the requirements of section 12 and comply.
This question, I think repeated question. We are trying to fill eForm active. SRN numbers of annual forms AOC4 XBRL and MGT7 are not getting pre-filled. We follow calendar year as financial year, and we are in compliance with the annual filings till year ended 31st December 2017. However, we need not file for 17-18 as our financial year starts from January 1st and ends on 31st December every year. Hence, SRN of annual filing MGT7 and AOC4 XBRL are not getting pre-filled.
We have to check this. They have to raise a ticket. We have to check whether they have filed INC-28, where they have taken exemption and for the purpose of calendar year.
And,
if they have taken exemption and have properly filed INC-28, it will automatically get pre-filled.
Yeah. But they have to follow the uniform financial year under section 2 subsection 44, unless or otherwise they are exempted.
Yes.
Shankarji, I would like to request you to answer this, because this question is repeated. As government company is not required to file ADT1 while filing the eForm 22A, then error is showing that auditor's data is not available. How a government company file this eForm?
So, we have sufficiently answered. For the sake of clarity, I am again answering you. Every company, including the government companies, need to file INC-22A active form. We have not given any relaxation or exemptions either in the rules, neither in the act with regard to filing of ADT1. So, the government companies, you please file the ADT1 form, then you proceed for INC-22A.
That's all. The set of questions have been answered. Over to Mrs. Deepa of ICSI.
So, we have successfully completed this webinar, and we have seen that there are lots of viewers in this webinar who have joined this webinar. There were around 1900 viewers. So, thanks to you MCA, and for the benefit of viewers, we will also upload this video of webinar at the ICSI YouTube channel. Who could not join, they can watch there, and we will send the link to the all the members also. And for sparing the time, we are thankful to you all.